Hello and welcome to this webinar on human rights in the employment context, produced by the Vancouver Island Human Rights Coalition. VIHRC is a nonprofit organization located in Victoria, BC, on the territories of the Coast Salish peoples. So, what is discrimination and how is it defined in the BC Human Rights Code? Our definition of discrimination is when someone is treated differently because of their protected personal characteristics in a way that affects them negatively. What this means in the workplace or the employment context is that employers have a legal duty to provide a safe, harassment, and discrimination-free workplace. The BC Human Rights Code's protection from discrimination in employment is very broad. It doesn't matter if you are a temporary, part-time, casual, temporary agency worker, contract worker, independent contractor, domestic worker, or even a volunteer. You shouldn't be discriminated against or harassed when you are working. Discrimination often arises with the lack of knowledge and a stigma that is attached to mental illness. Stigma is a negative prejudgment. All too often, persons with disabilities are assumed to be unable to accomplish certain tasks based on the experiences of able-bodied individuals. Stigma can create an experience of the world where a person's worth is perceived to be solely measured according to their ability to be an effective producer of profit in a capitalist economy. The topics of mental illness and physical disability in the workplace and how employers manage them continues to be one of the most challenging areas of human rights law. Employers have two main responsibilities toward employees and people who apply for employment. First, employers must not discriminate on the basis of a disability or a perceived disability. Employers must also make it clear that harassment in the workplace will not be tolerated. Harassment must be investigated and corrected as soon as employers become aware of it, and every effort must be made to eradicate stigma and discrimination. Second, the BC Human Rights Code requires that employers do everything they can to accommodate an employee with a disability. Just as someone with a physical disability might need physical aids or structural changes in the workplace, someone with a mental illness might need social or organizational accommodations. The employer and the employee both have a responsibility to work together to choose and find appropriate accommodations on a case-by-case basis. Given how the tribunal has interpreted disability in the past, it seems likely that experiencing COVID-19 could be considered a disability. Employers owe their employees a duty to accommodate their needs associated with characteristics that are protected under the BC Human Rights Code. However, this is limited by the concepts of undue hardship and the bona fide occupational requirement. These will be discussed later. The code specifically protects people from discrimination on the basis of mental and physical disabilities. An employer must not terminate or refuse to employ a person because of a mental disability. Doing so would be discrimination in the area of employment. Discrimination can happen either when a person really has a disability or that they are perceived to have a disability. For example, terminating an employee based on concerns that they are at risk of developing a mental illness would likely be discrimination under the code. If an employer fires someone because they're on sick leave due to their disability, this would also likely be discrimination. Similarly, not hiring someone because they disclose that they suffer from a mental illness would be discriminatory unless there is a compelling reason via a job requirement, but we'll get into those exceptions later. Whether a condition or illness is a disability depends on the circumstances of each case, and not every illness or medical condition amounts to a disability protected under human rights law. The law itself gives a quite broad definition and leaves room for interpretation by the courts on a case-by-case basis. Disability in human rights law indicates a state that is involuntary and has a degree of severity, persistence, or permanence. Generally, a disability impairs a person's ability to carry out the normal functions of their life to some degree. The Supreme Court of Canada has said that interpreting what is a disability involves a flexible, multidimensional approach that emphasizes human dignity, respect, and the right to equality, rather than simply biomedical condition. A person may have no limitations in everyday activities except those created by prejudice and stereotypes. Some examples of recognized disabilities include dementia, attention deficit hyperactivity disorder, and attention deficit disorder, obsessive compulsive disorder, schizophrenia, bipolar disorder, and various other learning disorders or developmental disabilities. Drug and alcohol addictions are also considered disabilities under the BC Human Rights Code. So what we've been talking about so far mostly addresses direct discrimination, but there's also indirect discrimination. This is when a person is treated the same as others, but this same treatment has a negative effect on them. For example, a store that can only be accessed by stairs will have a negative impact on persons who use wheelchairs. Everyone in Canada is legally entitled to a work environment that is both inclusive and discrimination-free. Since indirect discrimination can have negative effects just like direct discrimination, it's very important for employers to consider their duty to accommodate. Differential treatment is sometimes needed to have an inclusive and equitable workspace. Under the duty to accommodate, employers are obligated to consider how their design and management of the workplace will impact different groups. If an employee faces a barrier that prevents them from fully participating in the workplace, the employer must provide reasonable accommodations short of causing them undue hardship. Each accommodation is assessed on a case-by-case basis, but can include things like providing building access, modifying workstations or uniforms, adjusting working hours or job duties, or creating inclusive washrooms. It's also important to recognize that accommodation is a shared responsibility between the employer and the individual in need. When there is a conflict between a mental disability and a workplace requirement, the employer has a duty to facilitate by adjusting the workplace to meet the needs or limitations of the employee. This is the duty to accommodate. So if you have a mental disability that interferes with your ability to meet a requirement of the job, you will have several important questions. How can the employer accommodate you? What is the process of accommodation? And is there a limit to this accommodation? To start, you, as the employee, must demonstrate each of the following to trigger the duty to accommodate. Usually this is done with medical evidence that you have a disability, the specific ways in which this disability imposes limitations to perform job duties, and what particular accommodations you need and how they're connected to your disability. Once this has been done, the employer has a duty to investigate and consider potential accommodations once they've been notified. You, as the employee, also have an obligation to participate in the accommodation. This can include providing the employer with information on your limitations and how they can accommodate your needs. So if the employer asks you to provide detailed information about your medical condition so that they can devise an appropriate accommodation, then assuming that the information and their request is reasonable and necessary, you must provide it. But the question of what is reasonable and necessary is difficult to answer. How much medical information do employees have to give their employer when they are asked for a disability, when they're asked for evidence relating to a disability related accommodation? The answer is pretty much that it depends. If your employer wants you to share your medical information, they should do so in writing and only ask for information that is specific to your medical condition requiring an accommodation. The information should focus on the particular issues relating to your accommodation needs, such as how much time off work you need or your ability to perform certain job duties. Generally, the employer can request the general nature of the illness and how it manifests as a disability, whether this disability is permanent or temporary, and the anticipated time frame for improvement, the restrictions or limitations that flow from the disability, particularly as they relate to the employee's duties, and any treatment or medications that may impact the employee's ability to perform their job. The employer does not need to know what the person's actual diagnosis is. More relevant for them is the accommodation question. What are the person's limitations? What is the prognosis and how long will it last? Is the disability temporary or permanent? Is it expected that they will eventually be able to resume full-time functions? How does this disability interact with the standard requirements of the job, and does it create any conflict? For employers and employees, it's also important to recognize that accommodation doesn't need to be perfect. It also cannot always be implemented instantly. The standard that the tribunal uses is a reasonable accommodation. But to be meaningful and reasonable, accommodation should always be guided by input from the employee who knows their particular needs. It's about taking steps so that disability is not the basis for exclusion from the workplace. So again, everything is case specific, but let's consider one general example. If an employee has a substance abuse issue, reasonable accommodations might include schedule changes that allow them to attend treatment or therapy. It could also involve adjustments to their job description or performance requirements, or even the provision of short or long-term leave to allow for them to receive treatment and recover. Other examples of general accommodations include reduced hours, a flexible work schedule, working from home, job sharing, split shifts, scheduling work only at one location to avoid moving around, frequent breaks, additional training, written job instructions, or even modified job duties or a modified work environment. Now, there are limits to what is considered a reasonable accommodation. This is called the point of undue hardship. Employers are legally obligated to provide employees with an accommodation of their disability to the point of undue hardship. Undue hardship means that the cost, which must be accurately set out and proven, to accommodate them must be so high that it would significantly interfere with the employer's business. Cost can mean the money that would have to be spent on an accommodation, such as how much it would cost to build a ramp or an elevator as an alternative to stairs, or changes to policy and procedure. For example, undue hardship might arise in a situation where the workplace is very small and the employer cannot withstand the loss of their employee for a prolonged and indefinite period of time due to the disability. Some of the factors considered when assessing undue hardship include financial cost, health and safety risks, the physical environment of the workplace, and the size and flexibility of the workplace. If the employer has made reasonable accommodations, but the employee is still unable to do their job duties for a lengthy period of time, the employer will likely have met their duty to accommodate. However, proving undue hardship lies on the employer. This favors employees. There are also some circumstances where discrimination in the workplace can be justified. This is called the bona fide occupational requirement. The bona fide occupational requirement comes into play when an employer can show that a discriminatory policy or practice is the result of a necessary requirement of a job. To give a simple example, if a person works as a driver or a pilot and they injure their eyes very badly, they might not be able to continue to work in the same job because of a requirement that these people be able to see well. So in certain circumstances, a limitation on an individual's rights may be reasonable and justifiable. The BC Human Rights Tribunal has 3 questions that they consider when looking at whether discrimination is permitted via the bona fide occupational requirement. The first one is whether there's a rational relationship between the adopted standard or the requirement and the tasks that are properly required of the employee. So for example, a rational job requirement for a lifeguard might be that they have a first aid certificate and swimming skills because they will need to rescue swimmers in distress. Second, was the requirement adopted in an honest and good faith belief that the standard is necessary for the fulfillment of that legitimate purpose? This question exists to prevent supposedly neutral policies that are really adopted to screen out particular applicants. And third, is the requirement reasonably necessary to accomplish that legitimate purpose? So for example, requiring that lifeguards be able to run 4 kilometers in 20 minutes might be connected to lifeguarding, since physical fitness is important when rescuing swimmers. It might not be necessary though. A better requirement could be a sort of swimming test. So if the employer can answer yes to all of these 3 questions, then the discrimination is likely to be justified via the bona fide occupational requirement. When this is the case though, there should be objective proof, such as statistics or medical evidence, that the requirement is actually necessary. So here's a flow chart to help consider whether employers owe a duty to accommodate and whether an employee's human rights complaint would likely be accepted by the tribunal. And that brings us to actually filing a complaint. If you think that you're being discriminated against, you can file a human rights complaint. For the tribunal to accept the complaint, the discrimination must involve a characteristic that is protected by the Human Rights Code, such as disability, and it should have happened within the past year. On occasion, the tribunal will accept applications that go beyond a year ago, but this happens very rarely. There are also protections for people who do file a human rights complaint. If you file a complaint against your employer, the employer is barred from retaliating against you. If they take action against you because you filed a human rights complaint, you can file an additional claim against your employer that will protect yourself. This is called a retaliation or reprisal claim, and it will be dealt with as part of the human rights application. So simply, the Human Rights Code says that no one can retaliate against you if you make a complaint or might make a complaint. If you are named in a complaint, or they are named in a complaint or might be named in a complaint, if you give evidence or help in a complaint or might give evidence or help, or if you take part or might take part in an inquiry under the code. So for example, if an employer identifies an employee who filed a human rights complaint against them as a troublemaker, and that employee has their hours reduced as a result, the employee could report this to the tribunal. And the employer would have to account for the reduction of hours in a justified way. If they rely on the troublemaker characterization that was connected to the complaint, then they will owe the employee back pay for the lost wages, and they'd have to restore them to their previous position. The employer would also likely have to undergo training to better understand how to avoid doing this in the future. So that's it for the presentation. Thank you for listening. And if you have any questions or want to file a complaint with the BC Human Rights Tribunal, please feel free to reach out.